us. Uh, Today we are going to be discussing the L-1 visa. Provide a basic overview of the L-1 visa, what it is, what it's used for, who qualifies for it, what companies can use it. My name is Jeremy Richards, and I am an attorney with Richards and Jurusik Immigration Law, where we only practice U.S. immigration. This is our specialty. And where we're located here in Buffalo, New York, we deal a lot with Canadian businesses and individuals that are coming into the United States from Canada to work and do business in the United States. There are a lot of our clients either already have operations in the United States, and some of them are seeking to open operations in the United States. And others are individuals who are working for foreign entities and their employer has a need for them in the United States and is looking to transfer them to work in the United States. I'm also here with two other attorneys in our firm, uh, and I'll let them introduce themselves.
My name's Christine Jurusik, and I'm a partner at Richards and Jurusik Immigration Law. And my practice area focuses mainly on U.S. immigration. I also do some Canadian immigration as well for U.S. citizens trying to get back into Canada. And let me introduce our associate, Rebecca.
Hi, everyone. I'm Rebecca. I'm an associate here. I primarily work on the business side of things, but I also do some of the family side of immigration as well.
All right, so let's go ahead and get started. So we're going to briefly cover what is an L-1 visa, the eligibility criteria for the two types of L-1 visas that you can get. One of them is the L-1A and the other one is the L-1B. The possibility of going from an L-1 visa to a green card or U.S. permanent residency, the visa options for spouses and children or family members of L-1 visa holders, also the renewal process or the options for renewal and the extension process, what they're often referred to as the same thing, and some challenges and considerations that we often run into when we're dealing with L-1 visas. So what is the L-1 visa? So the L-1 visa is a visa that was established through U.S. immigration that allows companies that do business internationally, that have qualifying entities in the United States and in foreign countries, to transfer specific employees from their international offices to their U.S. offices, and to allow them to do business in the United States and to facilitate the ease of transfer of those employees back and forth between these qualifying organizations. And it's really an advantageous visa for those companies that do qualify. It carries a lot of power in the visa world. It's a strong visa, is how I would put it. Those that are able to qualify for the L-1 visa, it gives them a lot of ability to either do business in the United States as a company, or as a company to send those necessary employees to the United States to help them continue to do business in the United States. And one of the big advantages of the L-1 is if you are certain qualifying employees, there is a direct path to U.S. permanent residency or a green card. And that's often a consideration that people have when they're considering a visa is, can I get a green card through this visa? Well, it's one of the only visa options that actually has a direct path. H-1B, TN, they don't have a direct path to the green card, even though you can get it through those visa options. There isn't a direct path like there is with the L-1 visa. Another thing or a benefit of the L-1 is for spouses, children to attend the L-1 visa holder to the United States, and a spouse gains work authorization as well and the ability to work in the United States. And there are some basic criteria for that L-1 visa. Foreign offices, for example, have to have been in operation for at least a year before it can consider transferring employees to the United States. And you have to have a qualifying relationship, parent, subsidiary, affiliate. And it comes down to the percentage of ownership of those entities. They must share control. So the entities that are transferring employees back and forth must share operational control and ownership. So existing businesses, And we'll either deal with companies that are already in operations and they have operations in the United States, or they plan on opening new offices in the US. So when it comes to existing businesses, the one of the main criteria, and probably the first criteria you have to look at to consider the L-1 visa, is there a qualifying relationship between a US company and the foreign company that plans on doing the transfer? And when we do this analysis, sometimes it's very straightforward. Sometimes a company and I'm going to use Canada for example, a company in Canada will have a single owner, and that owner owns 100% of the Canadian entity, and then that owner or that company opened up an office in the United States under that same ownership or management structure, and it's 100% owned by that same individual. Very easy qualifying relationship to identify. The most important thing here is control of those companies. We typically use the 51% rule. Is the US entity and the foreign entity, do they share 51% ownership? If they do, then there's possibility they could meet the qualifying relationship to facilitate an L-1 transfer. Uh, Both entities, if you're talking about existing businesses, must be operating for at least a year. Uh, the 1 year operation doesn't not qualify, and Christine will talk to that in a second, for a new company. But if it's an existing entity, it is not considered an existing entity for L-1 purposes unless both the foreign entity and the US entity have been in an operations and doing business for at least a year prior to the transfer. And there must be an office space or an existing US office. And that's really business specific or business type specific. But in US immigration, one of the regulations for an L-1 is that you have to have sufficient offices to support the operations of your business. An example I often give is a trucking company, for example. If you're going to be in the business of logistics and you have an operation that has trucks and drivers and dispatchers to facilitate that business, well, you should have secured a space or be operating out of a space in the United States that is able to support that type of business. Where are you going to park your trucks? How are the trucks going to be maintained? Where is the dispatcher working out of? So an office space that would support that is what they're looking for as far as the US office. And there has to be a clear connection between the company that's transferring the foreign office to the US office, and that connection must be maintained during this transfer. What does that mean? It means if you're transferring an employee from Canada to the US, you must maintain those operations for that visa to remain valid. So if you close down your foreign operations or your US operations during that visa validity, then that visa is going to become void. So the criteria for which that visa was approved must be maintained throughout the duration of the transfer. And the employer must also show that they have the ability to pay the wages or the employee's salary in the United States. It's a little bit different than other visas where, for example, an H-1B visa has what's called a prevailing wage determination, where the Department of Labor mandates how much somebody must be paid for an H-1B visa. Well, the L-1 doesn't have that strict requirement. But they want to make sure that the U.S. operations is in a financial situation that it is able to support the wages of the person being transferred, and that person is being paid a wage that's consistent with what somebody in that field would make in the United States. So they want to make sure you're not undercutting the U.S. labor market, but it's not as strict as the requirement, again, for the H-1B visa. And a reminder, or I guess to explain what it means to be doing business in the United States. And we run into this a lot when I'm talking to businesses when they're trying to determine whether or not they're doing business. I say, are you filing tax returns? Do you have invoices that you're sending to clients? Do you have products that you're producing? Or do you have a service that you're providing? in the normal course of doing business in the United States. They want to make sure that you are providing service, you're providing a product, you have employees, and you're actively doing business in the United States to qualify as an existing business. So just having a presence in the United States, just having formed an entity and purchased an office space isn't sufficient to be considered an existing business. Now, Christine will take over from here and she'll explain expanding a new business in the United States where you may be able to take advantage of that. But for purposes of an existing business, you must, it does not qualify unless you're actively servicing clients, producing products, or doing business in the US. You're on mute.
Pardon me. So this current slide here talks about new business expansion. So business owners or businesses that have an office outside the United States that are looking to expand into the United States and get access to that US market can take advantage of the L-1 transfer of employees based on being a multinational corporation if they have established a bit of a foothold here in the United States. And it doesn't have to go to the full extent that Jeremy was just talking about with the existing office where you have to demonstrate taxes and certain things like that. But you will have to demonstrate that steps have been taken to establish that new office before you can demonstrate that someone is able to be transferred to run that office. The first thing we look at is the qualifying relationship. So in setting up that new office in the United States, that relationship between the current office, the foreign office, and the new one in the United States needs to be related by ownership. And that ownership, as Jeremy discussed, can be set up as a parent subsidiary relationship, with the US company being either the parent or the sub, an affiliate relationship, and even a joint venture can work, or a branch office in certain circumstances. One of the main things that they look at to see whether or not you've taken the proper steps to establish your US office is whether or not there is office space. And this can be a bit of a contentious issue with certain industries because a lot of companies people are working remotely now, or they maybe have a workforce that's very international, and office space isn't required to do what they do. Unfortunately, for an L-1 visa, and if you want to take advantage of this immigration benefit, you are going to be required to demonstrate a physical office. And that office is going to need to be sufficient for your operations. So, whatever that means for your business, it could mean, something quite large. Typically speaking, if the business is just starting out in the US, a small office space can be sufficient in a lot of cases. And that, people often have questions about that, whether, like a Regis office or some kind of virtual space would be sufficient for this. And technically speaking, it's not. You need to have dedicated space for your business that you can put signage on. Oftentimes, we even asked people to provide photographs of the space, square footage of the space. And it's just one thing to keep in mind with this, because that is something people try to get around all the time. Another part of the demonstrating the new office is ready to operate is going to be that business plan. And we generally recommend that you get a professional business plan prepared that's going to demonstrate the eligibility of the new office in the US to support this new L-1 employee. So that's an important key aspect to the evidence that we generally recommend. In order to qualify for an L-1 for the new office, the immigration authorities are going to look at your employment abroad and what kind of role you were performing with your foreign employer. That employment needs to be either in a managerial or executive level capacity, or in a specialized knowledge capacity, in order to qualify you to come into the US on the L-1 visa, either as an executive or manager in the United States, or as a specialized knowledge employee in the United States. And there can be a mismatch there. So if you have managerial or executive experience outside the US, you can come into the US in an L-1B capacity, and vice versa. Sometimes can interchange those. So, the other part Jeremy was talking about is the financial evidence. There is financial evidence required, not to the extent that he was speaking about with respect to taxation, proof of taxes in the US, but financial evidence showing that the office is going to be able to support the employee that you're bringing into the United States, maybe by an investment made by the foreign company, or showing that the foreign company will be supporting the US company financially until they're up and running. Um, and so the new office, it really is a great option for people that are expanding their business or for businesses that are looking to take advantage of the US market and need to send somebody over to start that up.
And one thing to add is if you are the owner of the company, that would qualify under an executive role typically, to transfer yourself to the United States. If you are the one being transferred and you're the one that wants to facilitate that expansion in the US, we often help the owners of companies expand their businesses and be the first individual to the United States in that expansion.
That's a good point, Jeremy.
All right, now we're going to switch our focus more to the eligibility requirements for the individual employee applicant. So, the L-1A visa is specifically designed for the intercompany transfer of multinational executives and managers, which are distinct positions. So, to break it down, executives are primarily in charge of directing a company's management or a major function of that company. So, for example, executive responsibilities typically include making key decisions with limited supervision, setting goals and policies for the company's operations or for a major area within the company. And executives receive only general supervision from higher executives or the board above them. So what you're typically thinking about are your C-suites, so your CEOs, your COOs, and whatnot. Those are the people that are typically in these executive positions. Managers, on the other hand, typically oversee the work of other supervisors or professionals who hold degrees, or they can manage an essential function within the company. Managers are typically responsible for controlling and directing the organization, a department or subdivision of the company, managing the daily operations and setting operational procedures, and supervising other employees or manage a key function of the company without direct oversight. So typically, we want to see an organizational chart showing the employee's position in that managerial or executive role, and then if you're a manager, all of those people that you are kind of in charge of managing, all of those people that fall under your direction. And again, just to keep in mind, the executive or manager looking to be transferred to the US must have worked for that foreign office in one of these roles for at least 1 year in the last 3 in order to qualify. We'll move on to functional managers. Now, this is an option for those who don't have any direct reports or don't really manage others within the company. Functional managers are those who manage a key function or department of the company rather than directly supervising others. So their responsibilities typically include the management of that essential function that is crucial to the business's operations. They have authority over policies and decision making related to the function that they manage. They're usually operating at a senior level within the organization, generally have minimal supervision, and often they control the resources, budgets, and projects tied to the function they oversee. The key to this classification is that the role of the employee must be critical to the company's operations and must significantly impact its performance. So, to give a brief example of this, because this can sometimes be tricky to understand, we recently had someone who was the manager of product development for a company, and essentially, this individual was responsible for translating customer safety insights into product designs, and they guided the engineering teams to develop these products according to customer and market needs. So, this company was relying on the development of these products and technologies that this individual was working with, making his role that of a manager of an essential function for this company to operate. Now, moving on to the L-1A to green card process. So, the nice thing about L-1As is that they are dual intent visas, meaning that the individual can have non immigrant intent to remain in the United States temporarily to work, or they can have the intent to move towards permanent residency in the US. Now, to obtain a green card, L1A visa or status holders can apply through the EB1C category for multinational executives and managers. It's a separate category specifically reserved for those categories of employees. The nice thing is that there's no lengthy labor certification involved, as there is with other employment-based immigrant processes, and there's no certification with the Department of Labor, which really speeds up the green card timeline for those who hold this L status or these visas. In terms of applying for the EB1C green card, the employer has to first file Form I-140. This is the immigrant petition for alien workers, and this is meant to demonstrate that the candidate has the qualifications that are required of a multinational manager or executive. One important thing to keep in mind is that a priority date will be issued to you after the I-140 is submitted, and that priority date must be current before you apply for either adjustment of status or for consular processing to obtain the green card. So make sure you're keeping an eye on that visa bulletin to check your priority date and see when it becomes current. And then, of course, lastly, the final step is to file for the actual green card itself, either through adjusting your status from within the United States or consular processing from abroad.
I'd unmute myself there for a second. And just to add to this, we get this question a lot when you're going from L1 visa to green card. We often get new companies, and the new company will have just expanded to the United States, and they want to know when would I be eligible as a new company to sponsor somebody for a green card? And the answer is the company has to be in operation for at least a year. So it has to have at least a year operation in the United States to do the green card process. Plus, it has to demonstrate the financial ability to pay the wages of that permanent employee in the United States. So it has to have the financial resources available. And it has to demonstrate that it needs a permanent role as well. It's going to have permanent professional level work as a manager, executive, or functional manager in the United States for that individual. And unfortunately, there's no dollar amount I can give you or employee amount that I can give you that meets that criteria because it's specific to the type of business. But once you can demonstrate to USCIS that your company meets those requirements, then the US entity is able to do this L1 visa to green card process through the EB1C program. I just talked to somebody on the phone actually before this call, before this webinar, and I tell there's the two best ways to get a green card. One, marry a US citizen. Well, if that's not in the cards, in my opinion, the next best is this EB1C program. An excellent way to get a green card if it's available to you.
So the L1, let's talk a little bit about the L1B now. This is a slightly different than the L1A. It's still under the L visa heading, but the qualifications to meet the requirements for this visa are slightly different. So the L1B is premised on this employee being something called a specialized knowledge employee and holding specialized knowledge. That really is, to boil it down, expertise that is specific to the company that goes beyond what the typical industry standard would be for that position. And this, that sounds pretty general, but if you have to really boil it down to the industry and understand that type of position in the industry and to be able to know whether or not this person's knowledge is specialized. And the way it's demonstrated is typically with training records, evidence of work product, and even statistical information about the specific industry that the person is working in and how many people are qualified in their area of expertise. We used to think about it in terms of whether it would be whether this person's knowledge would be something that's easy to train somebody new in the United States to do. And if it is, then that's definitely not going to meet the requirements for specialized knowledge. But it even goes beyond that. Even if it would be hard to train somebody to do it, this person's knowledge needs to be somewhat unique and characteristic within that industry specifically. Um, Usually speaking, we see people qualifying for L1B if they are in some kind of technological role within the company. So engineers, computer systems workers, people with some kind of expertise on that business that's technological background. So somebody usually was going to have multiple months worth of trainings, maybe PowerPoint presentations to demonstrate that they've been taught what they need to know in order to operate in this specialized knowledge position within the foreign company before they would be qualified to be transferred. And that requirement we really need to show is 1 year of experience working in that specialized knowledge role. So somebody who started with a foreign company, perhaps right out of college, maybe they have a degree and not a lot of experience, would probably need to show more than 12 months of work with that foreign company in order to qualify for L1B, only because we would need to show that they were trained up to being a specialized knowledge employee before we could start counting that 12 months of experience. So it's important to keep that in mind when considering transferring an employee in L1B status. Um, Certain roles within the company are much harder to show that they have specialized knowledge than other ones. We spoke briefly here about people, with engineering backgrounds or technological backgrounds or even computer backgrounds within the company. Oftentimes, we see people try to approach this role from a sales perspective, and it is very difficult to get salespeople to qualify as L1B. We were successful doing that, I think, within the last few years, but the company was an extremely, highly technical company. And so the salesperson did have a lot of training in that area that we could demonstrate. But typically speaking, salespeople are not going to qualify either for L1A or L1B unless they can really show that they're a manager, leading a team, L1A, or L1B, that they have a lot of technological training in their background. We should note here as well that the L1B, unlike the L1A, where you can qualify for a maximum of 7 years of work, is limited to only 5 years maximum work. So you need to keep in mind with the L1B, if that employee needs to work for a longer period of time in the US, turn your mind to that early in their US employment, because it is a shorter period that you're able to renew the L1B for. And now L1B visa to green card is also slightly different than the L1A process to green card. That hurdle of having to deal with the Department of Labor through the what we call the PERM process, is going to have to be undergone if you're bringing an L1B visa holder towards green card. The L1A process, you skip over that whole step. On L1B doesn't have the same benefit, unfortunately. So that involves obtaining a prevailing wage with the Department of Labor to start the process, going through a recruitment, advertising to US people, and eventually getting this position certified with the Department of Labor before the petition can be filed, where the L1A can go straight to that petition step. Um, Typically these are under the EB2 or EB3 employment-based green card categories. That's going to depend on the qualifications of the green card holder and what the position requires. And that requirement that we demonstrate that there's no US workers to do the job can be problematic here. So you want to time this process properly if you can. If there is a glut on the market of people with your qualifications, it could be a lot more difficult to get through that recruitment phase without having a qualified candidate apply. And if that does happen, we have to go back to the drawing board and square one and start the process all over again. And certainly keep in mind country of birth and the visa bulletin requirements. Timing there also an issue. That also applies to L1A in certain aspects, but L1A falls under the EB1A category, which generally tends to be moving a little bit more quickly than the EB2 or EB3. And certain countries of birth can really have huge backlogs in the EB2 and EB3 categories. So keep that in mind.
And I would add L1Bs oftentimes when you're coming down to a test of the labor market. If you have a highly specialized product or a patent or something that you developed or service that you have that's unique to the industry, it can oftentimes give you an advantage for the perm because other people in the industry can't meet those qualifications, and it is specific to the position and to the company. So it is a much longer process, though, unfortunately, for those trying to go from L1B to green card. All right, so family members and spouses of L1 visa holders. So L2 is the status if you are a dependent of an L1 visa holder. And this applies to children under the age of 21, unmarried, and it also applies to a spouse. A spouse is somebody that you are married to. So we deal a lot with Canadians, and they have common law marriage in Canada. That does not qualify for US immigration. So if you're in a common law relationship, that's not going to qualify your spouse for L2. You must be married. Advantages of the L2. Well, the spouse is going to get what's called an L2S. And L2S status, to me, is one of the best statuses you can get if you're coming to the United States. It's actually way better than the L1 spouse's visa, because an L2S is blanket work authorization, meaning that spouse can work wherever they choose in the United States in whatever type of role they can legally hold in the United States. So you could work from anywhere at a fast food joint all the way up to an executive position in a company. Or so the options for a spouse of an L visa holder are very broad when it comes to employment in the United States. They could also go to school in the United States if they choose, if they want to pursue further education. Unfortunately, the children of L1 visa do not qualify to work in the United States, but they are eligible to go to school in the United States. And they're able to stay in the United States as long as the L1 visa holder is. So their status will be valid as long as the L1 visa holder status is valid. So for spouses, advantage of working in the United States, and in years past, you had to get a specific work authorization document if you were an L2S. They did away with that requirement a few years ago. So all you have to receive if you're a spouse of an L1 visa holder is what is called L2S status, and you will have authorization incident to status allowing you to work immediately in the United States without obtaining an additional work authorization document. So some of the common challenges and considerations that we run into with the L1 visa and handling L1 visas. So we deal a lot with Canadian citizens that are doing the L1 visa process. Advantage for Canadians: if you're a Canadian citizen, you can apply for L1 status for your initial L1 visa directly at a qualifying US port of entry or pre-flight inspection point. That means you can carry the application materials with you to a port of entry, and most of them nowadays require an appointment unless you're going through an airport. And the border officer will take your application materials, adjudicate it right there on the spot, and typically within an hour, they will admit you in L status, and you will be authorized from that point on to work in the United States. And Canadians don't require a visa, so that's why they're able to do this. They're visa exempt. So they aren't actually admitted on an L1 visa to the United States. They're actually admitted in what's called L1 status. And they will be issued what's called an I-94 record of admission, showing that they've been admitted to work in the United States under L1 status. When it comes to L1B applications, and Christine mentioned this, those ones face a lot more scrutiny than the L1A category. And I think the reason is, well, there's a lot of reasons, but one of the main reasons that is because you can argue anybody has specialized knowledge if you really want to. And a lot of people will argue that for individuals that they want to transfer to the United States that may not fit under the executive or managerial roles, but they really want this person to work in the United States. So they're going to argue, however they can to get that individual to work here in the US. So they often try to fit them under that L1B category. Sometimes you'll see individuals that may be more of a laborer or work in the trades or one of those functions that really isn't specialized knowledge, but the employer wants to send them to the US, so they try to fit them under the L1B. So for that, there's a little bit more scrutiny under the L1B category. Now, there are limits for the L1 and the L1B, the L1A and L1B. The maximum stay, if you're on an L1A, is 7 years. And I'll clarify this a little bit. 7 years of full-time employment. And if you are on an L1B, it's 5 years of full-time employment. You can get additional time on that if you exit the United States for a year and then come back in. So in order to get a new 7-year term or a new 5-year term, if you've been in the US full time under L1A or L1B, you have to depart the US for 1 year in order to requalify for time. Now, there is an exception if you are working in the United States on a part-time basis, or you're spending less than 50% of your time in the United States per calendar year. If you're doing that, then you will be able to receive unlimited extensions to your L1A or L1B. Also, if you're Canadian, you can continue to return to the port of entry after your initial L1 visa and continue to receive extensions directly at a port of entry. If you're full-time, however, you're only able to get your first L1 at a land port of entry, and after that, you'd have to file by mail with USCIS. So those are some exceptions if you are working part-time or spending less than 50% of your time per calendar year in the US under that L1 category. New office extensions are limited to 1 year, as Christine said earlier. And after that 1 year time period, you have to demonstrate to the immigration authorities that that business can support that role in an ongoing basis in order to get the next L1, which would be a 3-year extension. So if you're a new entity in the United States, it's very important that you commence operations in that first 1 year time period and you hire employees that would support the extension of that visa. If you're spending more than 50% of your time in the US during that new office extension, the extension that you request will have to be done through USCIS. And if you're a small company, that can be a severe disadvantage because USCIS standards for approving an L1 petition are much more stringent than they are at a port of entry. The port of entry, we found in our experience, is much more favorable for small businesses, whereas the USCIS definition says if you're not, Apple or one of these large corporations with multi offices all over the world, they don't even want to entertain your application. So something to pay close attention to if you're a small business doing this process. And last point of advice, make sure you check your I-94, and that is the overriding document. If you're coming to the United States as a Canadian or any other individual, they're going to issue that I-94 admission record. That I-94 admission record is your official proof of your authorization to live and work in the United States. It'll indicate the status under which you were admitted, the day you were admitted, and the day your status expires. So you need to make sure that you are compliant with that. And if you are doing part-time work in the United States or you want to take advantage of the spending less than 50% of your time a year in the United States, it's up to you to track your travel history, to track the amount of time you're spending inside and outside of the United States if you want to take advantage of applying again at a port of entry in the future and extending beyond the 7 and 5 year limits. Hopefully those of you that attended or watched this were able to get an idea of what the L1 visa is and the advantages of the L1 visa. If you need any more information, if you have questions for us, feel free to reach out to us through the contact information provided. We handle L1 visas on a regular basis. We do them a lot for companies expanding operations into the United States and primarily from Canada. So companies in Canada that want to tap into the US market take advantage of this L1 visa. And not only does it give you the advantage of doing business in the United States if you qualify, But those individuals that are seeking permanent residence in the United States, if you own a company and you're expanding it, it's one of the best ways in order to expand your business to the US as well as to obtain US permanent residency. Thank you for joining us today, and hopefully this was informational for you, and we hope to see you again in the future. Have a good day.